So yes, thank you all for being here today. My assistant, Veronica, will pass you over the microphones. And let me seize the opportunity now to introduce our panelists. First, Mrs. Maria-Manuel LEITÃO-MARQUES. She is a member of the European Parliament and part of the S&D group in the European Parliament. Of course, she's the vice chair of the Committee on the Internal Market and Consumer Protection, the all well-known IMCO committee, and also a member of the Committee of Legal Affairs, the Jury Committee, which takes the lead in the negotiation of our directive. And she has been appointed also as Shadow Rapporteur of the Digitalisation Directive 2.0. Welcome, Ms. LEITÄO-MARQUES.
First of all,
I just make the presentation of all panelists and then I will give you the floor, of course. So on your right-hand side, we have Ms. Cohen. She's a commercial magistrate specializing in commercial law matters. She advises the Spanish Ministry of Justice on national and also international commercial matters, having participated already in the registration or the negotiation of the Council of the European Union in the field of insolvency, company law, and also corporate governance. So you're a real expert in this field. Ms. Cohen is also the Spanish representative now to the European Commission's group of experts on company law, the so-called CLEC. So welcome, Ms. Cohen. And I go further on Ms. Cohen's right-hand side. We have Mr. Sebastian Zick. He's a lawyer and the head of the commercial law unit of the Hans Boeckler Foundation, Hans Boeckler Stiftung, seated in Düsseldorf, Germany. He provides advice to employee representatives on supervisory boards, mainly. So Mr. Zick is a national and also international expert on topics of European company law, and especially in the field of corporate governance and co-determination of workers. You have also served, if I'm informed correctly, as an expert for the German government and also Parliament and the European Economic and Social Committee and last but not least the OECD. Welcome, Mr. Zick. And then I follow with my dear colleague Corrado MALBERTI. He's an Italian notary since 2008 and the chair of the CNUE working group of company law since 2011 already. So we have a bulk of experience sitting here. From the notarial side, you are also an expert of the recent developments, of course, in EU company law. From the Digital Tools Directive, I remember vividly our vivid exchange also on the Mobility Directive, of course, and the current proposal that we are about to discuss. You are also an associate professor of commercial law at the University of Trento, and of course, we are happy to have you here. And Mr. Sauer, I have already introduced to you. So I would like to start now with my first round of questions and address directly to Ms. LEITÄO-MARQUES. So on 7 September, the jury committee in the European Parliament discussed Mr. Emil Radev's report on the Digitalisation Directive, his draft report, so to say. So what is your opinion on the draft report? Where do you see a need for improvement, or is it everything very uncontroversial? Please, take the floor.
Thank you. Thank you very much for the invitation, for this discussion, so important. So important for the European Union because we need to speed digital transition to be competitive in the global world. And so for that purpose, we need to promote digitalization of different aspects of our public and private services, and these of course include companies. It's a very critical point because currently 45% of small and medium-sized enterprises, that are the majority, large majority of companies in Europe, have a very low level of digital intensity. And so the Commission is very ambitious in these proposals. The aim is that 75% of EU companies use cloud, artificial intelligence, or big data in 2030, and that more than 90% of small and medium-sized enterprises reach at least the basic level of digital intensity. But I should point that what we consider to be basic now will be much more demanding in 10 years or even less. In my opinion, even today, basic digital intensity should include the use of tools of artificial intelligence. Everybody needs to know what's an algorithm, to give an example. This is the broad context in which we should read this proposal. As you know, and the Commission said before, the main aims are to facilitate cross-border companies, integrate more our internal market, increase transparency and cut red tape. That is a very important point for me, through the use of digital tools. And in order to achieve some of these aims, the Commission wants, once more, assure the application of the once only principle. It's a very interesting principle, and the companies not need to submit the information when setting up a branch or company in another member state. This is a very important principle, not only for in this context, it's a very important principles for other kinds of obligation that companies have today in order to cut red tape. And the President von der Leyen mentioned in the State of Union speech this year that we need to make it easier to do business in Europe. And I think this proposal is very important to this goal. One key way to achieve this is by exploring the potential of interoperability. We speak a lot and frequently on interoperability, but we need to use it to reduce, to cutting red tape and to reduce bureaucratic procedures. The Commission also suggests the creation of a EU company certificate, and it's a very, very good idea. The standardized certificate will be accessible online in different EU language. You don't need to translate, and to certificated translation, you know all the bureaucratic involved. I have a very positive approach on the proposal and also on the amendments of my colleague from EPP. So I think that this is a file, as we refer in the Parliament, where the consensus are going to be easy to achieve. It's a file easy to negotiate. It's my approach, it's what I think. It's a very good proposal from the Commission, but we can improve it as normally we do in the Parliament. For example, the rapporteur suggests that EU company certificate should be accessible free of charge to companies and interested third parties, such as authorities. It's a good idea to motivate, to push for the use of this certificate. I also think it's very positive that rapporteur clarified that documents transmitted via digital means should not be denied legal effect or be considered inadmissible solely on the ground that they are electronic form. It's something we did in the regulation on the digitalization of cross-border judicial cooperation. Having said this, there is still scope to improve the proposal. For example, when it comes to information that companies have to disclose, and that would be included in the European Union certificate. I give only two examples. probably the sector where they develop their activities is something could be interest for statistical reasons, or the numbers of workers, at least once a year, could be also a number of employees. I think it's information that could be relevant for policymakers as well as for authorities implementing the legislation that targets companies. These are just a couple of ideas which I believe should not be very controversial. In the end, I think we all share the same goal of using digital tools to facilitate operation in the EU and to trust in these kind of tools. And of course, there are other regulations, as you referred in the introductory remarks, such as identification, EU identification, and other files that contribute in that purpose. But this is a very important, at the end of the day, if you make our market more transparent, we are able to control with data, using data and digital data and reliable data. It's a very important point. We can use artificial intelligence also to control some risk areas in a more target way, and this is also a very important result if we improve our digitalization of our companies. Thank you very much.
Thank you very much, Ms. LEITão-MARQUES. A risk-based approach is something we could also use when discussing about the AML directive and package, but now we are focusing on the company law directive. And well, so thank you very much for sharing this very positive stance of the European Parliament on this file. So you stressed that we have the draft report from MEP Ralf at hand. You, as shadow rapporteur, are receiving it very positively, and if I understand you correctly, there is still room for improvement, surely, but nothing stands in the way for efficient and quick negotiations, so that the European Parliament is on track in terms of timeline, as suggested by Mr. Sauer. Thank you very much for your opening statement. Now, one of the co-legislators is the Parliament, the other one, of course, the Council, and I warmly welcome again Ms. Cohen. So what are the Council's stance on the proposal? Do you have any insights on the negotiations and the way they are moving forward? Because before entering into trilogue negotiations, of course, we need a general approach from the Council.
Thank you very much. Good morning. If you don't mind, I'm going to follow my speech in French, which is almost my second mother tongue. Tout d'abord, je voudrais vous remercier de m'avoir invité et pour participer à cet événement. Pour moi, c'est un honneur de pouvoir le faire. Et c'est magnifique de pouvoir partager cette table ronde avec mes collègues. Et je remercie aussi tous ceux qui sont ici ou qui suivent l'événement virtuellement. Et après ça, en ce qui concerne votre question, et comme vous le savez, l'Espagne a pris la présidence de l'Union européenne, du Conseil de l'Union européenne, dès mois de juillet. Et comme présidence, nous sommes obligés à soutenir une position impartiale sur tous les dossiers. Et ce ne signifie pas que l'Espagne n'a pas une position sur ces dossiers, mais nous représentons le Conseil, et alors c'est nécessaire d'être impartial. Et je suis au courant de l'évolution de ces dossiers en concret, en particulier, car je fais partie de l'équipe de la présidence espagnole et aussi je fais partie de l'équipe de négociation. Et je suivis ces dossiers dès Madrid. Mais à partir de la prochaine réunion, je devrais aller venir à Bruxelles. Et depuis que la Commission a fait public le dossier, la proposition de directive, le 29 mars, des réunions du groupe de travail au Conseil ont été liées. Et pendant le mois d'avril, de mai, de juin, et puis la présidence espagnole a donné un délai aux représentants des États membres pour faire des commentaires par écrit. Et tout ça est vers avoir et préparer un premier texte de compromis. Et l'idée, c'est de pouvoir commencer à examiner le texte de compromis à partir de la prochaine réunion qui aura lieu prévisiblement le prochain 17 octobre. Et dans l'ensemble, la proposition mérite une évaluation positive, car l'objectif est à poursuivre et doit mériter une valorisation positive. Et c'est très important pour la sécurité économique et la sécurité d'un point de vue juridique, et d'avoir confiance et transparence dans l'environnement des entreprises. Et c'est très important que les entreprises, les autorités, les parties intéressées puissent avoir accès à des informations fiables sur les entreprises. Ça ne signifie pas que nous n'avons pas des points qui peuvent poser certaines questions, certains problèmes. Et je pense que l'article clé, c'est l'article 10, et sur le contrôle préventif. Et c'est un article très important et dans le système qui établit la proposition de directive. Pourquoi? Parce qu'il répond à un but très louable, et c'est d'établir un système harmonisé de contrôle préventif et bien fait par une autorité administrative et bien fait par une autorité judiciaire et par les notaires, comme suggère le Parlement, et aussi le groupe informel d'experts sur le droit européen de la Commission, le so-called ICLEC. Mais ces contrôles préventifs, on doit le faire au moment de la constitution des sociétés et de l'établissement de l'acte constitutif et de l'approbation de ces statuts et de la société ou de toute modification de ce document. Et c'est un élément très important. Pourquoi? Parce que jusqu'au moment, il n'y a pas en Europe, à l'Union européenne, une harmonisation minimale sur le besoin de faire ce contrôle préventif. Et ça, c'est très important pour avoir la sécurité juridique. Mais je pense qu'il y a des aspects que peut-être on peut améliorer. Pourquoi? Parce que ces aspects peuvent poser des questions ou des problèmes pour certains systèmes juridiques. Et par exemple, l'article 10 prévoit la possibilité pour les États membres d'exclure ou de déroger ce contrôle préventif dans les cas d'utiliser des modèles prévus à l'article 13 non-IS de la directive. Et ça, par exemple, pour l'Espagne, mais aussi pour d'autres systèmes, pour d'autres pays, pareil, comme par exemple l'Allemagne, l'Autriche, et peut poser des questions. Et en Espagne, par exemple, c'est absolument nécessaire de faire un contrôle préventif sérieux, en tout cas. Et d'abord, après ça, il y a une autre question. Et c'est que je pense qu'on doit mettre en relation ou interpréter l'article 10 par rapport à l'article 16 ter. et qui fait référence au certificat de la Société de l'Union européenne. Et on doit souligner que ce certificat doit être accepté ou devra être accepté dans tous les États membres comme preuve concluante de la constitution de la société et des informations énumérées dans l'article. Quel problème ou quelle question peut poser cet article, l'article 10, par rapport à l'article 16 et terre? Le problème, c'est que dans certains pays, dans certains systèmes juridiques, il est nécessaire on a le principe de fonction équivalente. Ça, c'est-à-dire les actes publics étrangers, extrajudiciaires, peuvent être inscrits dans les registres publics, par exemple en Espagne, s'ils remplissent les conditions établies dans la législation spécifique applicable et à condition que l'autorité étrangère soit intervenue dans la rédaction de l'acte en exerçant des fonctions équivalentes à celles exercées par les autorités espagnoles, dans notre cas, et dans l'affaire en question, et quels sont les mêmes effets ou des effets plus proches dans les pays d'origine. Par exemple, si on a un certificat d'Allemagne ou d'Autriche, en Espagne, on n'a pas de problème, parce qu'on sait que le système de contrôle préventif et les fonctions exercées sont les mêmes. Mais ce n'est pas le cas de notre pays de l'Union européenne. Alors, ça peut poser des questions. Et puis, il y a des autres questions qui peuvent poser des problèmes pour certains groupes de stakeholders, par exemple les taxes, ou par exemple la question relative à les sanctions en cas de ne pas notifier les modifications prévues à l'article 38 et 40. Et c'est tout. Merci.
Merci, Madame Cohen. Merci de partager la perspective du Conseil avec nous ici. Je vais répondre un peu et essayer de résumer en français aussi. Donc, vous venez de partager votre réception, votre approche aussi positive de la proposition de directive, mais aussi, bien sûr, il y a un certain espace d'amélioration et vous venez de mettre le doigt sur 3 éléments surtout. Premièrement, la question de l'article 10 et le contrôle préventif, administratif, judiciaire ou par les notaires. Et si j'ai bien compris, et ou les notaires, c'était ça, c'était un élément d'amélioration proposé au sein du Conseil jusqu'à présent. C'est bien noté, c'est aussi une position des notaires et Maître Corrado MALBERTI va élaborer un peu là-dessus, mais aussi la question de l'équivalence des fonctions des registres, de ce contrôle préventif des données des sociétés. Là, vous disiez que voilà, il faut un contrôle pas seulement minimum, mais un contrôle sérieux pour que les données soient vraiment fonctionnellement équivalentes. Et ça, c'est un élément crucial pour vous dans les négociations jusqu'à présent au sein du Conseil, c'est ça?
Oui, tout à fait. Et aussi, je pense que le succès du système prévu à la proposition va dépendre de la fiabilité des données fournies par les États membres et la comparabilité des données.
Bien entendu. Donc, vous avez eu la traduction, je pense, c'est bien entendu cet aspect-là. Merci pour votre statement initial. Maintenant, peut-être on a eu le Parlement européen, on a le Conseil. Mr. Sauer, would you like to respond directly to these first initial positions of the co-legislators?
It's already on? Okay, fine. Well, first of all, I think the most important reaction is that it's very good to see and hear that indeed there's quite some hope that this could be a smooth sail, that we're not too far apart, that there's room for improvement, that I had already said initially, that there always is, but there are other files where the positions are much further apart. So I think that's very good to hear. On the points raised, I mean they're known to us. I'm not sure. I mean, I think the last intervention showed that what exactly the issue is. It's the balance to be struck between, on the one hand, ensuring sufficient trust, and how far do you go there, how strict do you have to be there, and then on the other side, how far can you then go with respect to recognition of documents in another member state. So I mean, there's an obvious link between these two things. If we sort of if we turn the screw on one side, it might have an effect on the other side. So it's a delicate balance, and that's what we have tried to strike. You of course always can find a bit of a different balance, and that's what ultimately the two co-legislators will have to see where they find the middle ground. Maybe just on the EU company certificate. I mean, again, there is first of all the link to Article 10. So indeed, if there is a very good control that one can trust on what comes into the register, then that's already an important element, because the company certificate is an extract of that. We have other mechanisms in terms of obligations for companies with a sanction to file any changes, so that's also an important element of keeping the data and the information up to date. So all of this together will, on the one hand, ensure that the data is correct in the register, and then there are of course also certain safeguards around the certificate itself, in terms of authentication, for instance, and then of course you also have for the EU company certificate Article 16e, the safeguard, so the ultimate safeguard, if there are doubts, reasonable doubts about the authenticity of the document, the origin, then an authority will be able to ask questions back to its register, and then ultimately the register where the data comes from, to carry out a check and maybe not recognize if these doubts are not addressed through these requests. So that's where we try to find a balance. We don't want to, of course, make it too complicated, have too many checks and again ways maybe also for member states to not recognize documents, because then we will just simply lose the whole effect that we want to achieve, that it's easier for everybody, for companies, for public authorities, to rely on data that is held in a register in another member state. So that's I think that has been our struggle. That will be, I think, the struggle in the on each side when they form their positions, and then when we all come together. On the free of charge, maybe just to say EU company certificate. The proposal doesn't say that there should be a fee. It just says the fee should be capped and should not go beyond administrative costs. The reason why we haven't gone so far is saying it should always be free. I mean, there is actually a provision which says a company should have the possibility to receive it once per year for free. We didn't want to go beyond that because simply there's the financing model of registers, and some rely on certain of these fees to carry themselves. So another balance to be struck. There are different interests at stake here.
Thank you, Mr. Sauer. It's true. It's always about striking the right balance. And even if you have a proposal at hand which is broadly welcomed, the devil more often than not is in the detail. And understandably, there is something at stake, especially for the states, because they want reliable, accurate registers. And now, for striking the right balance and for at the same time facilitating cross-border business for a digital European economy, well, the data must be reliable, this is for sure, and it's not that easy as it might appear at first glance. But thank you very much for your insight from the Commission. If I say there's something at stake, there's certainly also something at stake for the employees and the employee representatives, and so I'm happy to have Mr. Dick as one representative of one important stakeholder in the whole process. So, Mr. Dick, civil society organizations as well as trade unions are always closely following European files and European company law initiatives in the EU as 5 years ago. So what is your take on the proposal so far, Mr. Dick?
Thank you for having me. For first of all, after having heard the Parliament, the Council and the Commission, it's a great honor to speak as one of the stakeholders. And certainly for the employees and the trade unions, this initiative is very important because also the employees and the trade unions rely on the on good information and on relevant information. And so, first of all, we find this initiative very positive because it gives an extension of information. But on the other hand, exactly like it has been discussed by now, it is important that the information is reliable and trustworthy. And there certainly is a bit our concern, because this is one of the concerns. The other concern, as you already mentioned from the Parliament side also, is the question of which informations will be offered. And we think the information must really be trustworthy because it depends on the question of, for example, social standards which are at stake, on false self-employment, on letterbox companies, but also if you take the coherence with other company law issues like the cross-border conversions directive, we have the relevant issue of the negotiated employee participation, information and consultation rights between companies and employee side. And in my view, the whole issue is about abuse in the end, control of abuse of rights. And so the result of these negotiations in the cross-border conversions and cross-border divisions is actually relevant also for the certificate issued for changing the seat from one company to the other. And certainly there it is important to have a reliable register, which is cross-border reliable, and which shows also for the stakeholders all the information at stake, which is the employee numbers, like you mentioned. It is also the place of management, certainly, which we have. And then the question, has there been negotiation started, and has it been completed? And has it fulfilled the rights of the employees in this process? And so even in Germany, if you think of the SE companies where you have this negotiating process, it is difficult to have the right information from the registries and from the courts also, because it's very complex. And so it's easy to say we need to have trustworthy information, but in the practical process, it's not so easy in the end. And there I see some of the risk for the employee side, but not talking about risk, also at the same time the chance to have better information and to have more information, because in the end, employee rights like works councils, European works councils, participation rights, all rely on the thresholds of employee numbers. So we need employee numbers for the company, but also for the group and for the plants, actually, if we want to deal with it. So actually, it's important to have more information and have reliable information for us. Maybe it's a bit particular to the employee interest, but I think it gives an insight of the problematic practical concerns also.
Yes, absolutely, Mr. Zick. I think you are raising here an important point, and the link also between the mobility directive, because as we all know, for instance, the mandatory negotiation process about co-determination is triggered when, for instance, in the outgoing member state, there's a 4/5 quarter or threshold reached in terms of co-determination rights. But of course, whether this 4/5 threshold is reached or not depends on whether the figures, which are also displayed in the register or wherever, are reliable and accurate. So whenever we talk about different angles or aspects of this directive, we come down to the same question, appears, or it comes out right now even, that data must be reliable, data must be accurate, and this could even lead to a better functioning of the economy in Europe. Thank you very much for this insight, Mr. Zick. Now, Corrado, you as a chair of the CNUE working group on company law, can you maybe a bit more elaborate on the notary's position here?
Yes, if I may take. Thank you very much, Peter. And I should say that many of the things I will say have already been mentioned by the speakers. There are many good things in the proposal, things that we like. The first thing that I think should be mentioned is that, as was said by the representative of the Commission, we now have truly minimum preventive controls when we incorporate the company, when we modify the bylaws, the statute of the company, and this is for sure something that we see with favor. We will come back to that in a few seconds. More information available, which is, again, something that we like, because more information is something that we can use in our practice, in our profession, and for this reason, we consider it a valuable addition to the already good situation we have, in fact, regarding the information available in business registers. Then we can say that this results in having better information, and again, also the interconnection of registers is something positive, but we should also be aware of the fact that this interconnection also brings some risk, because the rules applicable to these different registers are different, so it should be clear what rules will be applicable to each register, because the Boris, the heavy brother of the BRIS, I would say, because it's for beneficial owners, is subject to different rules, to a different legal framework from the information we have in business registers. Also, the purpose of the information in business register is really different from the one we have for beneficial owners. Finally, other good aspect is for sure that we have this extension to commercial partnership, and we see this as really positive, because in fact, commercial partnerships are becoming more and more actors of cross-border activities, because now they are vehicles also for financial activities in many cases. So they are operating at a cross-border level. It is not just their dresser that maybe is placed on a border town in a member state of the European Union, as it is frequently mentioned as an example. No, you have really financial companies that are built as partnership, operating at a cross-border level, managing hundreds of millions of euros. So to know something about them would be quite important.
Especially in the private actor, equity sector. Yeah.
Exactly. That is exactly what I was mentioning too. What I was thinking too, we have, for example, this partnership in Luxembourg. Essentially, they are the vehicle for financing almost all activities in the European Union nowadays, or could be. But we also have some open questions. And here I come back to the preventive controls. We need to understand what is the situation now, and it is a situation that dates back to 1968. And the situation that we have in the current Article 10 is a situation where we have 3 available types of preventive controls: administrative, judicial, or notarial. Actually, the Article 10 currently says that you should have a judicial or administrative control, or if you don't have any of these controls, you may have the control carried out by an authentic instrument. But the preparatory works were really clear that, in fact, this third control was a control by notaries. And it was also clear at the time that it was possible to have a combination of these controls. So even if it was not expressly said in the directive, this was what was in place in countries like Italy, Germany, and the Netherlands. In Italy, you had a double control, notarial and judicial. Then we moved to a single notarial control. In Germany, you, Peter, had, and you still have, the double control. And in the Netherlands, they had the double control, notarial and administrative. And in many states, we still have also, we have the double control. And I think nothing should be changed from this perspective, because the real risk is that the harmonization, which should improve the controls, will result in lowering the controls, in having less controls in some member states, because we should also remember this is a minimum harmonization directive. And it shouldn't become the focal point, the minimum standard that is set by the directive. Because then, instead of having better information, you could have worse information. Other things that I think should be mentioned are also already are things that have been mentioned already by the other speakers. The EU company certificate is a nice box, but again, we need to know what is in the box and who prepares the dish we are going to eat. And even more, I would say, delicate is the digital power of attorney, because the format, again, is digital, is uniform, is not even harmonized, I would say, really uniform in this case. But then the applicable rules will be different, and we have different ideas of what is a power of attorney. For example, in Germany, there is this idea of the procura, with a K, which is not an idea we have in other member states. And in fact, if there is not an international convention on the harmonization of agency law, we have the UNIDROIT Convention of 1983 that was incredibly unsuccessful. Maybe it's because it is really difficult to harmonize this type of instrument. But we are not really against this type of instruments. We are just suggesting that maybe we shouldn't give too much legal value or effect to them. So we are ready to improve these tools. So for example, for the EU company certificate, the key problem was that of having this conclusive evidence value. And this is something that we found a little problematic, because we already have rules on the value of the information in business register. This is Article 16. So why do we add an additional layer of rules just for the certificate? For sure it is proof. We agree that it is better to have it than not to have it. But then to say that it is something that by definition cannot be challenged, because this is what conclusive means, is something that we think goes a little too far, exactly. Final point, once and only principle and the breeze, and then I will be done. What can I say? I think the breeze is really important because it makes available the information at the cross-border level. The once and only principle is important too because it doesn't overburden companies. But we should be sure that the information that is exchanged through the breeze is not acquiring a legal value that it doesn't have in the country of origin. So once you have, for example, information coming from the Irish business register to the Italian business register, since you are downloading the certificate in Italy, it shouldn't result in giving a legal value to this information that it doesn't have in Ireland. Also, and this is really my final remark, the BRIS shouldn't become a bottleneck. We should allow practitioners to continue using the current methods to exchange information. It is a paper way, to be frank, but in many cases it is far more practical to use the paper way, and we have already that, for example, in cross-border merger situations. To give effect to cross-border mergers, in Italy, for example, you can either use the BRIS or rely on paper documents. And in many cases, if you want to have a certain date, a certain effect for transactions with 100 million euros at stake, it is better to have it in paper than to rely on notifications that maybe can come late or can be jammed for some digital problem. Thank you.
Thank you, Corrado. So to take up our discussion here now, j'ai une question pour Madame Cohen. Donc, la Commission reconnaît bien le principe du contrôle public préventif dans le droit des sociétés européen. Pourquoi vous pensez que c'est tellement important? Vous avez déjà un peu abordé ce sujet, mais peut-être vous voudriez élaborer là-dessus un peu. Parce que ça, c'est une perspective des États membres.
Oui, cette idée est très importante et c'est pour ça qu'on peut voir dans la proposition de directive l'importance du système d'avoir un contrôle préventif d'une façon harmonisée. Et ça c'est très important. Pourquoi? Parce qu'il faut lutter contre l'abus des structures des entreprises. Et on peut le voir aussi, si on lit le considérant 7 de la proposition de directive, que dit que la disparité entre les systèmes de contrôle préventif entre les États membres entraîne un manque de confiance dans les documents et les informations fournies sur les entreprises parmi les États membres. Ça, c'est très important. Pourtant, c'est très important d'avoir un système harmonisé, surtout pour les situations avec une base transfrontalière.
Donc, est-ce que c'est correct de dire si on lève ou on met le niveau de contrôle préventif un peu au-dessus, on pourrait atteindre un niveau où on pourrait vraiment dire maintenant c'est fonctionnellement équivalent, maintenant on a atteint un niveau de contrôle préventif public de sorte qu'on peut vraiment facilement reconnaître tous les données qui sont enregistrées dans les registres. C'est ça un peu l'idée que...
Tout à fait d'accord.
Parfait, parfait. Merci pour cette clarification. Donc, Madame LEITÃO-MARQUES, we have now talked about the importance of public preventive control. And if, from my experience, and when I was working in London, for instance, in the city of London as a lawyer, from my experience is when registers are not reliable, you will find workarounds. And a workaround in the common law system is that you rely on legal opinions, which are then made by the law firms, which cost a lot of money, not that reliable neither. But the idea to discharge public preventive control and put them onto private players, so a private control of data register. What do you think about such an idea?
I will answer when it comes to these proposals in specific, because it's a very critical information we are going to share, and we are talking about the acceptance of documents across member states. As the Council said before, in the position of the Council, there are different situations in different member states and different levels of trust. So it's a very critical point in this proposal, because we are asking all member states to accept EU company certificate as conclusive evidence of incorporation of a company and of the information that it includes. So authorities need to be able to trust that the appropriate and preventive controls have taken place to assure its accuracy. So there are very good reasons to believe that reliable public preventive control, which does not mean two controls or more than two, for instance, administrative and notaries. I know there are some member states that have these kind of controls, no problem with this, but a reliable and good control doesn't mean necessary two controls, as the Commission seems to favor in Article 10 and Recital 9, in our opinion, is preferable. This is because this kind of actors are strictly supervised, and special because they act only with the public interest in mind and not with the interests of their clients as other kind of actors, private actors would be. Thank you very much.
Thank you very much. Now turning once again to Mr. Sauer. Well, we see that the co-legislators and also some stakeholders express a bit of a concern of this principle of mutual recognition. We have talked about some possible solution. What would be interesting for the audience here in this room and also online would once, of course, what is the reaction of the Commission to these kind of ideas, and also maybe two detailed questions. What about data which are already in registers but which are due to more lenient legislation in the past because the new minimum standards are about to be introduced going forward? So how would we deal with these maybe not so reliable data which are in the current registers? And second, in general, what about the idea of if one non-reliable data infects the whole reliability of one register, and then it goes so on, because these data are used in a cross-border situation, then they, so to say, infect another register. So what is the Commission approach on these certainly pivotal questions within the further negotiations of the file?
Well, as I said before, we are certainly in favor of, first of all, good control mechanisms, as well as good mechanisms for companies, that push companies, force companies to correct incorrect data. That's also, I think, relevant for legacy data that you mentioned. And so, in principle, the stronger we can make this control, the better. But of course, bearing in mind that there are member states that pride themselves of, I don't know, doing, you can form a company in 18 minutes, or was it seconds? I don't know. But there are those that I don't know, maybe have neither judicial or administrative control or notary control, but they have lawyers that maybe do this. So, all of this to say, there are a number of interests to be taken into account. Certainly, we should not end up with the lowest denominator, because it will simply mean that if we don't ensure sufficient trust, then we will not convince any of the co-legislators to do what we want to do in terms of recognition across border or reliance on data in another member state. So, again, sorry to repeat this, but it is the balance that we need to strike. We should make it as stringent as possible. We cannot change the fact that there is legacy data in registers. It can nevertheless not mean that now we are forever prevented from trying to facilitate the use of such data. And frankly, even without the system that we have, I'm not so sure whether this kind of infection that you have in mind, it can absolutely be prevented. Because I mean, if you don't have something like the once-only principle, for instance, what happens is that you will probably pay a lawyer in the other member state to check what is the data about the mother company, for instance, that wants to create a subsidiary. And what are they going to do? They're going to look into the register there. So I mean, and if the data is wrong in that register, that will also infect ultimately the other registers. So I'm not quite sure whether. So all of this to say, we have to have sort of. I mean, we need to be reasonable, I think, a bit. We can probably not address everything. What we can do is to try to push hard to have something which is sufficiently high in terms of checks and in terms of obligations on companies that ensures sufficient trust. And if at some point there's wrong data, well, I mean, at some point, if it really matters, it will probably come out, the same as it would have come out for the register where it was originally. And, well, first of all, the company should have corrected it. If it hasn't, then there will be enforcement. And I think that's probably as far as we can go.
Which is a very understandable position from the Commission side. And there's always a possibility of some evidence control. If data is evidently wrong, false, then the register, which is about entering this data, can say, no, please, stop.
But what we should not do, I think, is because then we simply undermine the whole philosophy of the proposal that now for everything we introduce possibilities for member states to sort of step back from that. On a sort of generalized basis, I don't trust that member state because I just don't trust their system. That's just undermining the internal market and the whole. I mean, all the benefits that we strive for would be lost. So we should rather work on the controls and obligations.
And the idea and the concept of functional equivalence, is it something that?
And then, but I mean, we're trying to ensure the functional equivalence through Article 10, for instance. Yes. Well, maybe we have to work on that, and then we have to see how far we can push it, how clearly we can describe the type of control and the type of checks that need to be carried out. But if you then start to go beyond that and introduce concepts where then member states have again, I mean, who's then going to say, like, I don't know, is this still functionally equivalent? Is it sort of a bit too different from the other system? What needs to be the same is what's in Article 10. So the core of this needs to be set out clearly, and then we should be able to rely on that.
Thank you very much, Mr. Sauer. Turning to Corrado once again, some practical aspect here is the work with the BRIS. You already highlighted that the BRIS should not be a bottleneck. There should be also other ways to communicate, to get the relevant information. Are there any other aspects from a pure practitioner's position you would like to add here in terms of the BRIS? Because I think the improvement of the working of the BRIS is something extremely positive, which has been highlighted by all speakers here.
Yes, I believe so. And I would like just to say that for sure the basis of all, I would say, verifications we carry out is the information we find in business registers. But we should also say that this information is just an ingredient that then need to be prepared in the correct way. So, for example, if I retrieve information from the German business register, I wouldn't dare interpreting exactly what conclusion can I derive from that information, because I'm not educated in German commercial law. Actually, I know a little bit of German commercial law, but for many member states I don't know much. And to some extent, this possibility of relying on information at the cross-border level starts from the assumption that we have the same rules in all member states, which is not true. So, for example, if you see legal representative indicated in Italy, and you pass an instrument or you conclude a 3 million euros contract based on that, maybe then you will discover that there are some legal limitations to the power to represent the company that a German lawyer, a German notary will never know. So in practice, what is going on today is that we ask the colleagues or a lawyer or somebody else just to say, look, I have retrieved this information from the register. Can I rely on that? Is this the legal representative? Does the company exist? These are certification of 4 lines, 5 lines, not even the expensive legal opinion you have from the common law countries. But these are essential to ensure that a company, for example, is correctly represented, that the company exists, and that you can have a transaction frequently involving millions of euros. And to be frank, this morning we had a meeting at the CNUE, and between the meeting and coming here, I was discussing with a Swiss notary exactly about that. You need to provide me a certificate of 5 lines saying this company exists, based on the information you have in your business register, which, by the way, is really similar to the German business register. The person that will appear before me has legal power to represent the company, and nothing prohibits that person to carry out that transaction before me.
Understood. So it's some sort of practical interoperability, and also that you have other means to check the data, not only the BRIS. Thank you very much, Corrado. So I have to announce that Mr. Ralf Sauer, he has now to leave us, unfortunately, because he has to join the trilogue negotiations. Again, we are all the more pleased and thankful, grateful that you have been here and participate so actively in the panel discussion and your keynote speech. Thank you very much again, and so I will give you the free way to your negotiations.
Yeah, thank you also to you. I'm sorry for leaving.
Maybe one further question to you, Mr. Dick. The expansion of the public preventive control and the minimum standards, etc., from limited parties or limited companies to private partnerships. Does it help from your perspective in terms of co-determination rights or more in general employers' participation?
Clear answer is yes, it does. Because well, the question of co-determination on supervisory boards, and also the question of works councils, but more the question of participation, is very much connected to circumventing the rights of employees. And this problem is a big problem for the German lawmaker, actually. And one possibility to circumvent co-determination in Germany is using partnerships, or also the foundation or other legal systems. And it is also always relevant to know the number of employees, to know the legal status of the company, the legal status of the whole group, participation, because this is all relevant for the question if there's a possibility to have further participation rights. And so it would be even better if we would have included foundations in the information system and not only partnerships.
So a clear positive vote from the Hans Boeckler Foundation. Understood. Ms. LEITÃO-MARQUES, we were also discussing within the framework of this directive about the fight against anti-money laundering. Do you think this directive, with all the preventive controls that it is about to introduce, can help in the fight against money laundering?
As you know, this is a problem, and we need reliable companies too, not only reliable certificates and reliable controls. We need reliable companies, and it's good for economy, it's good for employees, it's good for all of us, and also for public authorities. And so we need to fighting some kind of practices. This is not this directive, of course, of this objective of improve transparency of this kind of data, and also improve the quality of data. That is a very important point. And in that sense, it complements anti-money laundering directive because more transparency and easier access to the information. This is a very, 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 very important point. Easier access to information, because sometimes we have the information, but we don't know where is the information and how to access it. About companies will help authorities in their investigation. For example, facilitate tax authorities work preventing the misuse of shell entities for tax purposes. And moreover, I'm thinking a bit beyond this legislation. If you have more data about companies, reliable data, we will be able to target the investigation, as I said before, to specific areas or companies of higher risk with the use of tools of artificial intelligence, and we can apply a risk-based approach, as you said before. This is something we are experimenting in different member states for other purpose. For instance, in Portugal, we are developing a very interesting project in order to improve the activity of our market surveillance, the main market surveillance authority, using data from companies, different kind of companies, in order to investigate only the areas of more risk and concentrate the resources in the more problematic areas or more problematic actors. So I think to have this data at the European level, as we are trying in other areas, we are doing a very good job in order to promote European data spaces. It's a very important point, not only for European Union as a global actor in the digital world, but also to trust and have more transparency in our economic activities. Thank you very much.
Thank you. So it's all about building bridges between the different initiatives so that they can work together to fight, especially the fight against money laundering, fraud and terrorism financing. Madame Cohen, si vous aurez le droit d'avoir exprimé un souhait pour le processus législatif, qu'est-ce que ce serait votre souhait, et est-ce que vous pensez que les traditions, les systèmes des États membres sont suffisamment reflétés dans le projet de directive?
Et merci de votre question. Et moi, je pense que je peux assurer sans risque de me tromper que la proposition de directive répond à l'idée de respecter les traditions de chaque pays. Et pour nous, par exemple, on peut voir ça, par exemple, si on lit les considérants 8 et 9 de la proposition. Pour nous, pour Espagne, mais aussi pour autres États membres, il est très important de pouvoir continuer et avec notre propre système de vérification et de contrôle préventif de la légalité des sociétés. Et en Espagne, ce contrôle le fait tout d'abord les notaires qui sont mentionnés à la directive, à la prochaine directive, et puis au moment de l'inscription pour les greffiers. Mais pour nous, l'intervention des notaires est essentielle. Alors, mon souhait serait de pouvoir conserver ce système de contrôle préventif de la légalité.
Merci, Madame Cohen, et je vous remercie personnellement en tant que président du CNUE de votre soutien dans le processus législatif. Maintenant, je pense qu'il reste un peu de temps pour des questions. Do we have still enough time for questions from the audience? Are there any questions? Question to Veronica. How much time do we still have? 5 minutes, so it's excellent. So we have 5 minutes for questions from the audience, in presence and or online.
Is it on? Okay. If there are no other questions, then I take the floor because I have a question myself. There have been propositions that we could use digital tools or automatic tests to check everything that is entered into the register. I wonder what other people think about that proposition and which parts you think could be digitalized and which should rather stay at a human being and should be checked by a person.
So you're referring to the human factor within the use of AI. By the way, it's a nice novel from Graham Greene, The Human Factor, which I recommend to everyone. May I put this question to you, Ms. LEITÁO-MARQUES? What about the human factor in the use of preventive controls?
Other sectors?
In every sector you want.
I'm very positive in the use of AI. We are discussing a lot in the Parliament. We are now in the trilogues about the AI Act. But I think we can improve a lot our public administration in different areas. This is one of the areas. Using AI, not only in terms, especially in terms of prevention, that is, we can use AI instead of solve the problems. If you have reliable data on that, and data is a problem, we are not discussing here, we refer frequently interoperability, but I know from my own experience, not in Parliament, but before in the Portuguese government, that using interoperability is not easy because we need standards. And we need the same standards, and we need semantic interoperability, not only technical interoperability. And the interoperability is a basic condition to have data at European level. Without good data, we have not AI tools to develop. But AI can be used in terms of these kinds of surveillance and to identify and to orient our risk-based approach to some areas or to some companies or to some countries or to some regions, and also can be used in other different ways to share information in order to simplify and cutting red tape in different procedures. We need to simplify our procedures. This is why I'm discussing about double controls. When I proposed, for instance, to add some information in the certificate, of course, if it is possible, if we decide to do that, we need to use interoperability to change the information between different authorities. That is AI for less bureaucratic procedures and AI for more reliable procedures. It's a positive use of AI to improve the quality of our administration in different senses.
Understood. And in terms of doing the scrutiny of the company data to be registered with the company registers, so I understand from your ideas that AI could help here, really could help to accelerate the process, make it easier.
I'm not an engineer, but...
You're not an engineer, me neither.
But I discuss a lot with engineers,
Yes.
specialists, and data analysts, and so on, because we organized in Portugal in 2017 a very ambitious project, how we can use AI to improve our public administration. And we met at that time all our specialists, and we asked them what can we do for us. And so we developing 70 prototypes. We are working with them. I refer one of them to experiment. We need to experiment before scaling because these are new tools and we need to experiment how to use them before scaling.
So AI as a facilitator.
AI as a facilitator.
But could you agree that ultimately it should be a human being that says thumbs up or down?
Human-centered AI. Ultimately, we need a human being to confirm. As a facilitator for our activity. AI as augmented intelligence, no, as substitute of human intervention.
Fully understood. And also thank you to you from the S&D group for the support in this file. I think that should not be a closing statement, but I think we all agree, and this discussion shows it very well, that we have a very good draft proposal. There is some room for improvement. There are some critical balances to strike, but if there's a political will to close this file before the elections, I think we would all be happier people.
This very important point of the file is also AI literacy, and when it's only for engineers, specialists in AI. All of us, notaries, lawyers, public officers, members of the parliament, we need AI literacy in order to know how to use AI in our professions, in our initiatives, in our projects. I don't know how to build an algorithm, but I know that the reliable data are important in order to do it work.
Understood, understood. So do we have any more questions from the audience? Maybe one online question? No? No online. So it was all crystal clear, apparently. So we have no further questions. So I thank you all very much for your participation, for this fruitful discussions here on the panel. Ms. Cohen, Ms. LEITÁO-MARQUES, Mr. Zick, Corrado, and of course Mr. Sauer, who's already fiercely negotiating the trilogue. Thank you very much.